Welcome to our webinar today. I'm Melanie Pimenta and this is Montague, and we are solicitors in the data protection team. Today we will be discussing the core aspects of data protection compliance, including considering what personal data actually is, what to consider when conducting a data protection audit, as well as briefly discussing upcoming developments in data protection and AI regulation.
So the first topic we will be discussing on this webinar is personal data, exploring what it is and what rights individuals have when their personal data is being collected and processed. Now, we're all very aware that our data is being collected, harvested and monetized for all sorts of reasons. We're also often aware of the basis on which our data is being processed, including consent or to perform a contract. However, having spoken to our clients, both individuals and organizations, our analysis tells us that actually defining personal data, being able to pinpoint it, locate it and understand it, remains a serious challenge. Hence our back to basics overview today.
So what is it? Well, the most important thing to know about personal data is that its definition is very wide. In fact, any data that relates to an identified or identifiable living individual is personal data. The living element is important here, as it will not be personal data if it relates to a company or corporate body. Additionally, in circumstances where you might have different pieces of data that individually may not identify anyone, that data will be considered personal data under the UK GDPR if, when collected with other pieces of information, it could lead to the identification of someone. So it's worth noting here that the data which has been pseudonymized, in other words, where it can no longer be attributed to an individual without the use of additional information, and therefore being more difficult to identify someone, is still personal data. So only once personal data has been truly anonymised, then that anonymised data is no longer subject to the UK GDPR. The legislation includes a non-exhaustive list of identifiers, but typically, whether in an employee, employer or business to consumer circumstances, typical examples of personal data can be very obvious. Someone's name, their home address, an email address, national insurance number, age, and even employment start date.
Now, however, this is rarely the only data that is being collected by an organisation. Often businesses will themselves collect or even use third-party analytics tools to collect usage data. For example, if one uses their online services. So this usage data might include types of content that their customer views or engages with, that features specific customers' use and the actions they take, their time zone, country, the dates and times of access, type of computer or mobile device, IP address, computer connection. Now, individually, this data may not identify anyone at all, but as we mentioned earlier, it will still be considered personal data if it's all collected together and then subsequently someone is able to be identified from it. Whilst we do not think that the law requires controllers or processors to identify a loose, hypothetical or tangential link between the pieces of data you may collect, it's clear there is an obligation to be constantly mindful of the information you are collecting and how/if it meets the personal data definition. Now, in certain circumstances, organisations may also collect special category data. Now, this is the data that is a lot more sensitive. So analysing what data you collect and knowing whether it is special category data is important, as there are extra requirements for processing special category data. Not only will you need to be able to identify your legal basis for processing the data, but you'll also need to identify a condition for processing the data. Now, these conditions include that the processing is in the public interest, that you have explicit consent, or that the organisation is authorised to do so by law. Now, examples of special category data include data that reveals racial or ethnic origin, personal data revealing political opinions, or revealing religious or philosophical beliefs, personal data revealing trade union membership, genetic data, biometric data such as someone's voice or appearance, data concerning someone's health or their sex life or even a person's sexual orientation. But why is this analysis important, and why do we need to be mindful of the data that you are collecting?
Well, once you have reviewed the data you are collecting, the reasons you are collecting and processing it, you now need to understand the rights granted to those whose data is being collected and processed under the UK GDPR. If any of the data we have just discussed is being processed or collected, the legislation states that the data subjects are granted a number of very important and key rights. The legislation splits these rights into those which are absolute rights and those which are not absolute rights. So, for example, those that only apply in certain circumstances. The absolute rights are, firstly, the right to be informed. This right creates a duty on the controller to provide certain information to the individual whose data is being collected. Such information would include any retention periods, what the data is being used for, who it is being shared with. As a data subject, you would likely find this information in a privacy statement on a website or terms and conditions in a document.
So we also have the right of access, which is probably the right that most people have heard of. It's more commonly known as a data subject access request, or DSAR or SAR. Now this is a very complicated area of the legislation, and we actually regularly advise both companies and individuals on how to respond to a subject access request, or indeed how to submit one. And we'll be running a full session on DSARs later in the year. In short, this is the right to obtain a copy of the personal data and other supplementary information. Now, the data controller has 1 month to respond to this request. However, there are a number of exemptions, and this can be extended by a further 2 months if the request is sufficiently complex.
So you've also got the right to rectification. This right allows data subjects to make a request for the rectification of any data that is inaccurate. This also extends to having incomplete data completed. So as part of anyone's processing activities, you should ensure that data is accurate in any event.
Absolutely. And the final absolute right is the right to erasure. This is another commonly exercised right, and our audience members may know this better as the right to be forgotten. Like the subject access request, there is a stringent timeline in responding to the request, and like the right of access, there are a number of key exemptions where a data controller would not have to comply with the request, such as for the establishment or exercise of defence of any legal claims.
And you've also got the non-absolute rights, and these are the right to restrict processing. This right is similar to the right requesting the erasure of the data. However, it can only be exercised where the accuracy of the data is contested. The data is being processed unlawfully, the company no longer needs the data on that individual, or there are some overriding legitimate grounds for restricting the process.
So we also have the right to data portability. Now this is actually one of the lesser known rights and not something that we see very often in practice. But essentially it gives the individuals the right to request that the data controller provides the individual's data in a commonly used or machine readable format, or to request that the data controller transmits this data directly to another controller.
Sure, and you've also got the right to object. This allows individuals to object to the processing at any time but in limited circumstances. There is the one absolute element to this right, which is that individuals will always have the right to object to the processing for direct marketing purposes.
So the final non-absolute rights are in relation to automated decision-making and profiling. Data subjects have the right not to be subject to a decision based solely on automated processing, i.e. the making of a decision solely by automated means without any human involvement, or automated profiling, the automated processing of personal data to evaluate certain things about an individual, again, without any human involvement. Now, understanding personal data and the rights attached to it is a difficult but necessary process, and we hope that this overview has provided some comfort and a useful starting point from which to conduct your own analysis.
So moving to the second topic of this data protection webinar, conducting a data protection audit and reviewing policies. Whether you had last conducted an audit since the implementation of the GDPR, which was obviously back in 2018, or since Brexit and the development of the UK data protection legislation, such an exercise is ongoing and is likely to be required more frequently as technology and the amount of data grows exponentially. So firstly, why should organisations conduct a data protection audit?
Well, the accountability principle in Article 5.2 of the UK GDPR requires a controller to demonstrate compliance with the data protection principles included in the UK GDPR. An audit is one way of achieving this, and this is reinforced by the ICO, which recommends that organisations show that they can do the following: monitor their own data protection compliance and regularly test the effectiveness of their measures, conduct routine ad hoc monitoring and spot checks, have a central audit plan or schedule in place to show planning of data protection and information governance internal audits, and also procedure audit reports, and have a central plan to take forward outputs. Sometimes it may be a data breach which triggers organisations to undertake an audit, but the key aspect is to ensure that organisations take a proactive approach. Next to consider is what areas or outcomes are you seeking to achieve when conducting an audit?
Yeah, there are various areas to consider when conducting a data protection audit, and these range from ensuring that the organisation's systems are less likely to be vulnerable to a cybersecurity attack, to changing the culture within the organisation as to how data protection is managed. For example, it may be that an organisation considers the following aspects. So firstly, ensuring that its policies, codes of practice, guidelines and procedures meet the requirements of the data protection legislation relevant to the organisation's processing of personal data. Next, ensuring that the organisation is in fact operating in accordance with its documented policies, codes of practice, guidelines and procedures, and to identify any potential gaps and weaknesses in the organisation's data protection regime. You may also want to review such procedures and gather in information which can be used as a reference against which improvements in performance over time can be measured. You can also increase the level of data protection awareness amongst management and staff, and also review how the organisation's relationship is with third-party processors, and if, for example, there are sufficient agreements in place. Finally, reducing the likelihood of errors of data breaches which could lead to complaints.
So there are two types of audit. We've got an adequacy audit and we've got a compliance audit. An adequacy audit requires a deep dive into what data processing is carried out, and this will ultimately involve an organisation understanding what personal data it processes, for what purpose, and whether there are adequate safeguards in place to protect this data. Following this exercise, an organisation will need to ensure that it has the policies and procedures in place to ensure compliance. So in practical terms, how is such an audit undertaken?
Well, Jacob, an adequacy audit may involve a questionnaire, but may also involve interviews with key roles in the organisation and a review of relevant policies and procedures. So linking back to the accountability principle, it is important that there is someone within the organisation who has responsibility for monitoring data protection compliance. For example, this could be an appointed data protection officer, or as commonly known as a DPO, or head of compliance. So compliance within the organisation can start to be achieved when senior management acknowledges what needs to be done to keep compliant with data protection legislation. So the audit may also involve checking whether the DPO or person with responsibility is regularly reporting to the board or highest level of management.
So next, an organisation should check what policies and procedures are in place, generally for the protection of personal data used in the course of business. For example, what policies and procedures do you have in place for the retention and deletion of personal data that's used in the course of business, and for complying with the principles of data minimization and accuracy? It would also involve checking whether an organisation's privacy policy has been updated to meet the requirements of Articles 13 and 14 of the UK GDPR to ensure fairness, transparency, and that data subjects are aware of their rights in respect of their data.
Yes, and it will also involve reviewing what IT infrastructure you have in place and whether such infrastructure is sufficient, up-to-date and compliant with data protection legislation, and guidance to ensure adequate protection of the personal data. So for example, we have recently seen that the popular social networking site was fined 12.7 million by the ICO for failing to safeguard children's data. It was established that a networking app allowed up to 1.4 million UK children under the age of 13 to use its platform, despite its terms and conditions specifying 13 as the minimum age to register an account. It was later discovered that at the time, this organisation's systems were insufficient to enforce this age restriction, and this organisation breached the key principle of the UK GDPR, which was the unlawful processing of children's personal data in an unfair and untransparent way. So the key message here is that ensuring that you have systems which are fit for purpose and that will remain compliant with the UK data protection legislation.
Absolutely. And another area to consider, and something we actually touched upon earlier, is what sensitive or special category personal data an organisation processes. Now, this is likely to involve what we would say, a sort of high risk processing activity, and therefore additional protections need to be in place. For example, when undertaking such an activity, do you have a data protection impact assessment or risk assessment in place? This involves weighing up the pros and cons or risks of undertaking such an activity and ultimately establishing whether such an activity can take place. Finally, do you have an adequate personal data breach response procedure in place? The starting point here would be ensuring that you have a data breach management policy in place so that all of the staff are aware of the procedure and then ensuring that this is being followed in practical terms. The larger the organisation, therefore the higher likelihood of occurrence of data breaches, and it is therefore important that there is a framework in place to ensure the strict and short timeframes are implemented by the ICO.
So the other type of audit we'd referred to earlier, a compliance audit, can be undertaken in a couple of ways, and this involves checking all aspects of the data protection compliance system within a particular area, function or department. So a functional or vertical audit will involve departments within an organisation reviewing its policies, procedures and processes restricted to the department itself. For example, it may be that a review is undertaken of the HR department to check how it collects and stores personal data, with consideration of the statutory retention periods or the retention periods which are stipulated by the organisation. Alternatively, organisations could conduct a process or horizontal audit which involves tracking a process from one end to the other, which will ultimately require the cooperation of various different areas, functions and departments within the organisation. So it may be that this identifies some data as being processed by third parties, which will involve the organisation checking that there are sufficient agreements in place to ensure it is clear as to each party's obligations, particularly when acting as controller or processor of the personal data. An example of this type of audit could be an assessment of the way in which the organisation processes data subject access requests. So in this particular situation, an audit would follow the progress of the data subject access request as it was processed by the various departments and staff involved.
Now, there is a lot which can be covered when conducting a data protection audit, but what we believe your key considerations and key takeaways should be are: what personal data does your organisation hold? What are the purposes for processing such personal data? Is there a lawful basis for processing that data? What steps are taken to ensure that that personal data is accurate, secure, and retained for an appropriate amount of time? Are there any procedures in place to ensure compliance with data subjects' rights? Are there policies in place for staff to follow when dealing with personal data or even data breaches? Are your organisation's IT infrastructure sufficient to protect the personal data and therefore comply with the legislation? And finally, do you have adequate agreements in place with third parties, particularly when transferring personal data outside of the UK?
So we want to conclude our webinar by briefly touching on upcoming data protection developments and the regulation of artificial intelligence, or AI. So in terms of upcoming data protection developments, on the 8th of March 2023, a revised version of the Data Protection Digital Information Bill, so the DPDI Bill, which would change the current Data Protection Act 2018 and the UK GDPR, was introduced into Parliament, and a research paper has been published. This bill, which aims to create a new UK data rights regime tailor-made for our needs, amended the original bill, where the Secretary of State explained that the changes would reduce compliance costs in the sector and reduce the amount of paperwork that organisations need to complete to demonstrate compliance, reduce burdens by enabling businesses to continue to use their existing cross-border transfer mechanisms if they are already compliant. Next, give organisations greater confidence about the circumstances in which they can progress personal data without consent. Next, increase public and business confidence in AI technologies. So we await details as to when this bill will be passed in Parliament. However, such changes will inevitably shake up the UK data protection landscape. And this is obviously all whilst the retained EU law data revocation and reform bill is being reviewed, in which the DPDI bill may seek to amend some aspects of the UK GDPR and Data Protection Act 2018.
So separately, the ICO has confirmed that it intends to update the following areas of specific guidance: deletion of personal data, public task as a lawful basis for processing, exemptions from the right of access, rectification, erasure, restriction, portability and objection in the DPA 2018, how to implement data protection by design, privacy enhancing technologies or PETs, security such as updates to previous guidance on top tips, asset disposal, practical guidance for small businesses, protecting personal data in online services, and also big data.
So we've seen considerable movement in the world of artificial intelligence since our last webinar. From the highly successful launch of Microsoft-backed ChatGPT, the more muted launch of Google's Bard, letters to the government from tech pioneers, or the questions of copyright infringement of music artists, it would appear that AI services, chatbots and software provide an endless stream of newsworthy items and opinion pieces.
Absolutely. And what's made this surge in AI awareness so palpable is the clear differences in opinion as to its risks, uses, potential, and need for regulation. So a group of AI experts and tech pioneers, including Elon Musk and Steve Wozniak, have called for a 6-month halt to what they describe as the dangerous race to develop more powerful AI systems. Now, the EU agrees, and Europol, the EU's Agency for Law Enforcement Cooperation, recently published their own concerns regarding the potential use of AI for phishing scams, spreading and creating disinformation, but also cybercrime.
Sure, and on the other hand, the UK has taken what it would like us to believe is a more pragmatic approach to regulation, which others have described as a light touch. So last month, the Science, Innovation and Technology Secretaries stated that if we legislate now, it will be out of date. And given the pace at which the technology is moving, they are probably not wrong. So this does not mean that the new legislation is not incoming, but for now, in order to create the AI-friendly environment the government wants, and to therefore harness the economic benefits, it is looking to existing departments, so the Competition and Markets Authority, to apply existing safety transparency principles to the field of AI.
Now, the ICO gives the impression that it agrees with this strategy. However, in its recent response to the government's white paper titled A Pro-Innovation Approach to AI Regulation, the ICO confirmed it would like close collaboration with the government to ensure that the pro-innovation approach is compatible with existing data protection principles and avoids any additional burdens on businesses. The ICO has also confirmed that it would welcome clarification on the respective roles of government and regulators in issuing this guidance. Thank you very much for attending our webinar. We would be very happy to assist if you require any specific advice on the topics that we've discussed today.